V. Hill and Alex Cervantes for the plaintiffs.
Good afternoon, Your Honor. This is Robert Schwartz on behalf of defendants Alec Baldwin and El Dorado.
Good afternoon, Your Honor. This is Nick Gouveia on behalf of Rust Movie Productions, LLC.
All right. We're here this afternoon on defendant Baldwin and El Dorado Picture Inc.'s renewed motion to stay these proceedings or stay discovery this proceeding pending the resolution of the criminal proceedings. So with that, Mr. Schwartz.
Thank you, Your Honor. Your Honor, I'm very mindful that this is our second appearance before the court requesting this relief. And the big difference between the last time we saw you, which I believe was at the end of August, and today is that the grand jury has delivered a criminal indictment on 2 manslaughter charges against Mr. Baldwin. And he is facing a very real threat that he was not facing at the time we saw you before of the criminal proceeding. And in that interim, 2 judges in 3 other civil cases, the civil cases in California arising from the same incident, those 2 judges in those 3 other civil cases applied the same facts to the same legal principles and decided that it was appropriate to stay the discovery or against Mr. Baldwin and his personal services company, El Dorado, pending completion of the criminal trial.
And so should I ask, was it pending completion of the trial or was it pending completion of the proceedings? I say that because with appeals and other things that can happen, that's a pretty significant distinction.
Right. And we're talking about the trial today. That's all we're asking for. And those judges were to phrase it in terms of criminal proceedings. But, Your Honor, what we didn't have when we were in front of those 2 judges, but we do have today is we know that in 4.5 months, the criminal trial will most likely be done. It's scheduled to start on July 10th. In this case, similar to the other cases in California, there's no discovery completion date. No discovery completion date has been set. There's no trial date in this case. And I think we can all have some assurance that discovery in this case will still be going on in September and October of this year, and even beyond that, most likely, after the criminal trial has been completed. What's going on here, and it's very clear from page 8 of plaintiff's opposition, that what this is about is attempting to force Mr. Baldwin to show up for a deposition during a period of time when he really could be working with us to prepare for his criminal trial, and repeatedly assert his 5th Amendment right. And they made that very clear on page 8 of their opposition. They want to create a record from which a jury could draw negative inferences against Mr. Baldwin by his assertion of his constitutional rights. Now, that's not a proper inference to be drawn, and it's not a proper reason to refuse a stay of discovery. And if the court is not going to allow the plaintiffs to have the jury draw those inferences at trial, then what's the point? There really isn't any of allowing the plaintiffs to create that malignant record over the next few months. And so while Mr. Baldwin is fighting for his freedom, here we are fighting over his money. The better course is to do like those other judges did and stay discovery against Mr. Baldwin, at least until the criminal trial has completed sometime in July. Thank you.
All right. And then there's the issue of the El Dorado Pictures, right?
El Dorado, yes. It's there. That is a company that exists solely to furnish Mr. Baldwin's services on this movie. He is the sole owner. He is the sole officer, the sole director. It is predominantly for business and tax purposes, but there's nobody else who can testify on behalf of El Dorado other than Mr. Baldwin. And that was recognized very clearly by Judge Ricana and forgetting the name of the other judge, that the stay, as a practical matter, the stay needs to be as to both of those related defendants.
All right. Thank you. Who's arguing for plaintiffs?
I am, Judge. Pick V. Hill.
All right, whenever you're ready, counsel.
Thank you, Judge. Your Honor, I think that defendants' pleadings make it clear that they intend to assert their Fifth Amendment rights under most, if not all, circumstances. The court mentioned the idea of the fact that the proceedings would not necessarily be concluded just because there's a trial date or even a trial. There are appeal stages that go on for years and years. We're all aware of those, of the Court of Appeals, the Supreme Court. And there will arguably be an argument by defense counsel that Mr. Baldwin is at risk well into the future, no matter what, pending appeals, pending decisions, potentially by prosecutors to bring other charges. I too was a little confused by what it was defendants were requesting, because in their motion for renewed stay, they requested a stay of discovery against them pending resolution of the criminal matter. Now, that criminal matter is, as I just said, something that could just go on ad infinitum. In their reply, they asked for a stay of the action. So I was a little unsure about what it was exactly they were requesting, but in either situation, Judge, Mr. Baldwin could go on for years and years claiming his Fifth Amendment privilege. Now, New Mexico permits a negative inference to be drawn by the exercise of the Fifth. That's codified in Rule 11.513, comment upon or inference from claim of privilege. So the law is what it is. This court has ruled previously on pretty much an identical motion. The court considered all of the factors put forth by defense counsel during the last hearing in August of last year. And the only thing that has changed is it is true that Mr. Baldwin has been indicted and there is a trial date set. But as these criminal matters go, it will always likely be an exercise of Fifth Amendment privilege by Mr. Baldwin. So plaintiffs would ask the court, having considered all of the factors in the past hearing, to allow this matter to proceed. In addition, plaintiffs would ask the court to set a scheduling conference in order to set deadlines so that we can get the ball moving on requesting availability by defense counsel and their witnesses for various depositions. I think without some sort of a court order in place and deadlines in place, plaintiffs are going to find it impossible to gain availability for depositions and further discovery of the like. As it was,
Mr. Behill, did you ask for a scheduling conference? I didn't see that in the.
I did, Your Honor. I sent that in several weeks ago.
Okay, on the 26th of January. Did you submit a proposed text?
I'm sorry?
Did you submit that? Sorry, just one moment. All right, apologize for that. I was getting so much feedback there for a moment. I couldn't clearly hear. So, Mr. Behill.
Yes, Your Honor.
I see you requested. Did you submit that to my proposed text?
I believe that's where we sent it, Your Honor, and I can resend it as well.
That would be helpful. I don't recall seeing that. I did not see that in preparation for this hearing, and that is certainly how people get before me to get those deadlines and scheduling orders that you're requesting. So Fair enough on that. And let me ask another issue, because at the last hearing, I think the bulk of our exchange was, and this is true with all counsel, was about the fact that some discovery could go forward, but that I did understand that there could be questions posed to the defendants that would quite predictably elicit a Fifth Amendment indication, and that I wasn't inclined to think that that would necessarily be appropriate. So I was trying to make sure that discovery happened in a way that it could move forward where productive, and not have everything stayed, but not be unfairly prejudicial to the defendant. So where has discovery gone from your perspective? By that, I mean the perspective of the plaintiffs.
Yes, Your Honor. So I was trying to be quite cautious given the court's comments during the last hearing regarding scheduling Mr. Baldwin's deposition. So I did not do that. I didn't request it, didn't do it. And I further refrained from submitting any interrogatories to him personally. So what we, the plaintiffs, did was we submitted a round of discovery to the third defendant in the case, aside from Rust and Mr. Baldwin. We submitted a round of discovery to Dorado Pictures and interrogatories, requests for production. Absolutely nothing productive came from that other than a litany of rote and template objections to every single thing we asked. And so I think that is a forecast into what we're likely to see in this case. The court has indicated they have other tools for protecting, like protective orders and other curative mechanisms. And I think those are of course, still available to the court as it sees necessary. But without the scheduling order and without the ability to proceed against Mr. Baldwin and the third defendant, Dorado, we're just going to be at a standstill. We've gotten some decent discovery from Rust, the other defendant, but there's a lot still to be done. And where defense counsel has now placed the plaintiffs in a position of having to send multiple good faith letters prior to filing our motions to compel. And so that's what is now in the offing. And I think it's only going to get worse with a stay and without a scheduling order that allows us to have deadlines that are forced upon all parties in order to meet discovery needs, such as the multiple depositions that are going to be required.
All right. And am I correct, as I saw preparing for this hearing today, that the plaintiffs have had discovery propounded to them and that they've answered that discovery?
That's correct, Judge. All three plaintiffs received a fairly large packet of interrogatories and have answered all of those and served them on defendants.
All right.
May I, Your Honor?
Yes, I would was about to ask you to. So yes, whenever you're ready.
So, first of all, we didn't put the plaintiffs in this position, okay? The New Mexico criminal prosecution put this case and these parties in this position, and we are trying to manage it as reasonably as possible. And so when we hear from the plaintiff about how we served objections to their discovery, what happened is when we got their discovery, we said, would you give us an extension of time to respond until the court rules on the pending motion to stay? It's a common courtesy. They refused. And so they left us no choice but to preserve Mr. Baldwin's rights by objecting to the discovery where it was objectionable. We have not served any interrogatories on the plaintiff. Our motion for this stay has not prevented the plaintiff from taking discovery from Rust Productions, the company that made the movie, that hired the people. It has not prevented them from taking third-party discovery if they wanted to, these depositions they allude to. We haven't stood in the way of that. And if that discovery needs to be taken in this case, there's nothing that we've done that would have prevented them from doing it. They haven't done it, and they have their own reasons for it, but that's not on us. The real question here is what protection? I mean, the court alluded the last time to some protections it could give Mr. Baldwin if the plaintiffs depose him in the next 4.5 months, which, as I've explained, is not a time deadline that the plaintiffs, that anything in this case imposes on the plaintiffs. What protection is there? And the court, we talked about it, but the court didn't say what it was. And if the court has in mind—
My recollection is that we discussed protective orders and motions for protection. We discussed if there were answers that were thought to be unacceptable, motions to compel. I think we brought all that up, as I recall.
Your Honor, what would the protective order say? I mean, a protective order is an order, but what is the protection the court would be providing under the protective order? That we didn't discuss. And the court—
So, Mr. Schwartz, I'm not here to be drawn into an argument with you as much as to tell you that my orders are often highly dependent upon the factual circumstances and legal arguments brought to me. So I'm not going to tell you what exactly an order would say that has not been requested. But I can tell you that it is a mechanism by which this court can control discovery and provide protections if necessary.
Well, that's what we're asking for now. It is a form of protection.
You're asking for one particular type of protection. And I will say you've clarified helpfully, because I agree that your motion that asked for a stay of discovery against them pending resolution of the criminal matter, which can mean a lot of things, was not helpfully specific. So it's helpful that you're telling me now you're looking for a stay as to these two defendants through the end of the trial.
I am, Your Honor. I mean, and I apologize for creating that confusion. I see what you're talking about. I agree with the court. Poor choice of words on my part, and I apologize for that. In that regard, I think, I mean, look, we don't know what's going to happen in this trial. And depending on the outcome of this trial, the Fifth Amendment issue could be mooted. I don't think the district attorney or the special prosecutor has said anything about filing other charges. I think that would create some serious double jeopardy issues depending on what happens. But none of us is in any position today to know what that means or what that could hold. But it is— as long as counsel brings that up, no protective order from this court could prevent or protect Mr. Baldwin from the use of any testimony or deposition he would give in this case from being shown to a grand jury. That's a case we cited. That's the In re grand jury case that we cited in our motion on page 13. So that's the only reason why I inquired what protection. I mean, if the court is— if a remedy the court would consider is to say that no, the plaintiff cannot allow the jury to infer anything from Mr. Baldwin's assertion of his right against self-incrimination, that could change the character of this motion. I accept the court's position that it can't rule in the abstract or here today how it would rule, but the simplest and most effective solution to this problem, given that there is no deadline in discovery, given that this criminal trial will be over in 4.5 months, is to say to these two defendants, plaintiffs, take the other discovery you need, and if the criminal trial is the end of that criminal proceeding, depose Mr. Baldwin. That seems to me to be, and that's what most courts have said, and it's what the judges in the 3 other cases have done. So I urge the court to take that simple approach and not allow the plaintiffs to create a record from which, in our view, they can prejudice Mr. Baldwin's rights at trial without knowing anything more about what the court might be able to do to prevent that from happening. So that's our position, Your Honor, and I thank you very much.
All right, thank you. I'm going to go off camera and mute for just a moment while I look through my sticky notes that I've put on your bound copy so I don't bang into the microphone. But I will be right back on with either follow-up questions if I neglected to ask something or a rule. Just a moment. All right, thank you very much for your patience. I believe I have answers to my questions. So my ruling is as follows, which is the motion is partially granted in that there'll be no depositions of Mr. Baldwin individually or 30B6 depositions related to Dorado Pictures, Inc. between now and the conclusion of the criminal trial in this matter. Following that trial, we can determine how discovery moves forward if needed in those areas. I'm not staying written to discovery. Parties have a continuing duty under New Mexico law to confer in good faith and work to see if they can confer and come up with discovery, scope of discovery that moves the case forward and is appropriate under the circumstances, and I'll expect counsel to do that. If there is a failure to answer that is objectionable, there's motions to compel. If there is the feeling that there's a need for protective order or confidentiality order or anything else from the defense, or I would say, I guess, responding parties, it could be at some point the plaintiffs, you can bring that to this court. But I think that's adequate protection going forward to protect Fifth Amendment rights and ensure that this trial or this litigation proceeds apace where it can. And I should also say, as it's been brought up a few times, nothing about this ruling is meant to be a criticism, veiled or others or otherwise, of any other judges in any other jurisdictions looking at this matter. I'm applying New Mexico broad discovery standards and looking to make sure that the trials conducted or the litigation is conducted appropriately under our law. So I wouldn't want to cause anyone offense on that front. Is there any ambiguity that I've left, Mr. Schwartz, as the person I'm going to ask to draft the order, because I'm partially granting your motion?
Thank you. I was going to ask if you would be issuing an order, so you've answered that question.
Yes.
When you say written discovery, I assume you mentioned interrogatories. Are you talking also about
requests for production and interrogatories.
Got it. Thank you. All right. Then no, I will prepare a proposed order and circulate it with plaintiff's counsel, and we'll submit it to the court.
All right. And any questions, Mr. Beal?
Yes, Your Honor, just one point of clarification. So your ruling relates to, as Mr. Schwartz has indicated, conclusion of the criminal trial scheduled for July 10th of 2024 in Santa Fe County. As I understand it, I just wanted to make sure that was the court's ruling.
That is the court's ruling. I will say, noting that sometimes we do a good job managing cases in this district, but sometimes delays happen. So if that trial is bumped back, I don't want the order to be drafted in such a way that we have to revisit it every time. But it is that trial that is currently scheduled in July, as I understand it, that I'm referring to. And it's the conclusion of that trial that would trigger the ability to request a deposition. And again, Mr. Schwartz, be aware that depending on the state of the proceedings at that time, you can file protective motions for protective order and things like that at that point. So it's not as if all remedies are no longer available to you, but that's when we can move forward with depositions.
Understood, Your Honor. All right. I'll work with counsel for the plaintiff to submit an order to the court.
All right. And Mr. Beal, I shifted on you there to someone else. Did you have any other questions?
No, Judge. It would only be contingent on other possible outcomes of the Baldwin criminal trial in July. For example, a hung jury or plea bargain, that kind of thing. But
well, I will be here. I don't intend to go anywhere. So if there are other developments or it goes in a direction that we can't possibly know at the moment, file a motion and get it before me, and we'll get it considered promptly. I think this matter was expedited, so you all know that if there are issues of some urgency, we can get them set pretty promptly. And again, to your request for scheduling conferences duly noted, and we'll get that set in the near future.
thank you, Judge.
Thank you, Your Honor.
All right. Thank you all very much. With that, we're adjourned and you're dismissed. Have a good rest of the afternoon.
Thank you.
Your Honor.